Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome. I'm Alicia Downey, and the title of today's episode is Dial L for Liability, Evolving Restrictions on Telemarketing to Consumers. We all hate spam phone calls, and increasingly we're all getting unsolicited text messages. But many of us might not realize that the activities that lead to our getting spam texts and phone calls are heavily regulated by not just U.S. federal law, but also state laws as well. Today, we're going to talk to a guest with a great deal of knowledge about these statutes. But before we do that, I want to welcome my co-host, Derek Jackson. Hi, Derek.
Hi, Alicia. It's great to be here today.
Derek, would you like to introduce our guest?
I would. Our guest today is Becca Wahlquist. Becca is a partner in the law firm of Kelley, Drye Warren, and she's the managing partner of their Los Angeles office. Becca has years of experience defending cases brought under the Telephone Consumer Protection Act, or the TCPA, as well as state unfair competition laws and false advertising laws. We invited her to be our guest after reading a very interesting article that she co-wrote for the summer 2022 issue of Antitrust magazine entitled Developments in Telephone Consumer Protection Act Law Following Do-Good v. Facebook. Welcome to our Curious Amalgam, Becca.
Hi, it's wonderful to be here.
Great. So let's get right into the questions. And first, I think it'd be helpful if you could let our listeners understand in broad terms how the U.S. federal laws as well as state laws regulate telemarketers in their interactions with consumers.
Sure. Well, the main law is from 1991, the Telephone Consumer Protection Act. And it's an interesting law because it's so old. And it was written before there were cell phones and smartphones and text messages and the kinds of computerized technologies we have now. And because it's an old law that has very high statutory damages that are uncapped, you've had decades of massive litigations being brought under this law. So the developments in the law have impacted not just telemarketers, but businesses calling their own consumers or texting their own consumers for a variety of reasons. Really, all texts and calls are covered by the TCPA. There's other laws like the telemarketing sales rule, and there are state laws as well, but the TCPA is the big behemoth.
And you mentioned that the TCPA has a private right of action with statutory damages. Can you give us a sense of what those damages look like?
There are two provisions in the TCPA that give private right of actions. One is for calls to telephone numbers that are listed on the National Do-Not-Call list if those calls are not done appropriately. Like there's existing business relationships and other things that can allow those calls, but otherwise you need to abide by the National Do-Not-Call list. The other private right of action is for certain technologies that are restricted and have extreme limits on when they can be used and what kind of consent is required. And those are three technologies: artificial voice calls and pre-recorded calls and calls that are placed with an automatic telephone dialing system, which is a defined term in the TCPA.
And my understanding is that the federal statute, the TCPA, allows states to enact telemarketing prohibitions that are more strict than the terms of the TCPA. So can you talk a little bit about what are some of the examples of divergence between the federal regime and those state laws?
Most of the state laws are about marketing calls. The state laws don't really get into the informational, transactional restrictions on technologies. But as to marketing calls, for example, if my number's on the National Do-Not-Call list and I've just gone to buy a fridge from a retail store, that retail store now has me as an existing business relationship for a certain amount of time. Under federal law, that time would be 18 months because I just made a purchase from them. So they could call me with a marketing call, even though I'm on the National Do-Not-Call list. But there's 4 states that have no past relationship exemption. So in those states, you can't call. There's 6 states that have a 6-month exemption. So you can only call within the 6-month period. And then there's some states that have a 12-month existing business relationship. So states have set their own laws. They also have different calling times. The TCPA isn't the statute that sets the calling times that the telemarketing sales rule is. And in federal, you can do marketing calls between 8 a.m. and 9 p.m. But there's a lot of states that have stricter rules, including some states that restrict all marketing calls on Sundays, some that you can't start before 9 a.m., some that you can't call after 8 p.m. Rhode Island caps the calls at 6 p.m. or 5 p.m. on Saturdays. So there's a patchwork of laws that need to be complied with. And businesses that are legitimate businesses that are trying to communicate with their customers work very hard to comply with all these laws.
Now, with the prospect of private rights of action and the stakes being as high as $500 per violation under the federal regime and perhaps a few hundred to thousands per violation, depending on the state, do they have similar statutory damages in the state laws or?
The state laws, there are some state laws that have pretty significant statutory damages. There's some new state laws that have come out in just the last 2 years that have either the same or higher statutory damages than TCPA.
Okay. Well, what I was driving at, though, is that these are sometimes very high stakes actions, particularly when they're brought in the form of class actions that businesses may face. So the question we had then is about the article that you wrote, which I think involved a class action. Is that correct?
Yes. The Duguid case, the Supreme Court case, had involved Facebook. And it was a situation where somebody that had been a previous owner of a telephone number had signed up to get certain alerts from Facebook via text. And then the phone changed hands and the person continued to get thousands of these text messages and brought suit, a class action suit. What the Facebook court decided was very significant. There had been a circuit split for years and on what is the definition of automatic telephone dialing system, like what kinds of systems are restricted by the TCPA. Because businesses that are trying to comply with all the laws and reach out to people who are finding themselves getting dragged into court saying you're using an ATDS because your computer could be used to randomly and sequentially dial numbers. But any computer can be used that way. So the Supreme Court really clarified that the statute says what it says and changed the game.
Reading your article and reading about the Duguid case, is the distinction here really between sort of the technology or the method that the company's using to contact people as opposed to the content? In the Duguid case, it sounded like Facebook was texting people automatically to notify them about unauthorized access to their account. You could imagine that being treated very differently than a more telemarketing type call, but it sounds like here the difference is really based on the method of contact.
Yes. So the problem with the TCPA Section 227A was, again, it was written in 1991 when technologies like artificial voice, pre-recorded call, and auto dialer were very intrusive cold call telemarketing. And it was back when every phone number in an area code would get called by an archaic computer trying to get anybody to pick up the line using these technologies that regular businesses weren't using. And then you fast forward, 35 years, and here we are in a world where automatic dialing out of a list of your stored customer numbers with a computer helping you do it, it's just not what was intended to be barred when the TCPA was barring systems that automatically sequentially generate and dial numbers. So that's what the Supreme Court clarified, but it isn't about the type of call. So the ATDS lawsuits were being brought not just for marketing calls, but for every kind of communication call. I mean, I've defended blood banks getting sued for saying, hey, it's your 6-week reminder where you can give blood again. And then it was like, that's an ATDS call and you don't have my consent, threatening the life of this blood bank. I represented a bank who got sued for those one-time passcodes that get to your phone and say, here's your passcode so you can enter your account. But a phone number had changed hands. And so someone's like, I'm not the one who's your customer. So I'm now bringing a nationwide suit on behalf of me and everyone else for all those passcode, messages. And I defended a company that got sued for sending a fraud alert that had been requested by the original owner of the phone, and the phone had changed hands. So one of the problems was that there was not a reassigned numbers database. There was no way to know, especially with cell phones, that numbers were changing. There now, as of the last 2 years, is a reassigned numbers database that companies can use to try to make sure they're calling the right numbers. But there still was always a risk that you would call a number that had changed hands. And the Supreme Court's decision defining what the technology is just kind of got rid of these really aggressive lawsuits about communications that we do all want to receive.
So that gives us a good picture, I think, of the current landscape. But I think we also want to talk about where things are headed from here and in this changing technological world. So is there any pending legislation right now in Congress or in the states that we should know about on this issue?
Well, let's start first with a few recent FCC orders. The FCC is the agency that interprets the TCPA, and just in recent months, they've come down with a few things. One, as I mentioned, was clarifying that text messages are covered by the National Do-Not-Call list, which had been kind of a question before because it wasn't specific. The TCPA is so old, it doesn't mention text messages. But something that's really going to help with spam marketing, so everyone's going to be happy to hear this, is that the FCC is closing the lead generator loophole. And it's announced it, and it's giving like a 12-month lead-in time for businesses to change their practices. But you know how if you ask for a quote on insurance on a website, suddenly you get called from 8 different insurance companies, maybe over a period of several days, you're getting a lot of calls. And that's because the lead company collecting your information sells that lead to multiple of its clients. And that's something that the FCC just issued this order in the last couple months saying that's going to stop. All consent needs to be one-to-one. And so if you want to call somebody, you can't say, I got this lead for somebody who wanted to hear about hairdressing opportunities. It needs to be, I want the hairdressing opportunities from Becca's salon. So that's going to cut down a lot on unwanted phone calls because the consumer will be able to choose how many and which places they want to call them. And so that the consent is tied just to a desired recipient. So that's a couple FCC things. There have been state laws that have reacted to do-good by reinstituting laws against auto dialers. So Florida, Oklahoma, now Connecticut have put in massive fines for using really any kind of computerized system, some would argue, in placing calls.
So looking at how the FCC is rolling out different interpretations of the statute, and as you mentioned, some initiatives, I guess, at the legislative level to tighten the restrictions rather than loosen them. What about the effects of new technology? You mentioned this federal statute was enacted in 1991. It's predated artificial intelligence. It's predated text messaging, really, as we know it. What about some other types of telemarketing technology that you think may or may not be covered, that maybe the state laws or federal laws need to be updated to handle? Is there anything on the horizon like that?
Well, the FCC also, in this flurry of activity, just recently clarified that AI calls are artificial voice calls that will be subject to the TCPA's restrictions. So that is, as companies are looking at all of the options that they can do with AI in sending calls or texts, they have to really look at how things are developing on the litigation front, because you have to have certain levels of consent, prior consent, to use restricted technologies.
I have a question. A call obviously is made through either a cell phone or a landline, right? And that's a voice call. A text message, again, goes to a phone. That's a digital phone that's capable of receiving a text. Do these statutes cover things like notifications by apps? Because those also interrupt in the same way a text or a phone call does.
Well, they don't, because they cover phone lines, and those aren't using phone lines. Is there an effort to potentially try to include those things? Yes. I mean, the truth about notifications, though, is you can set your own preference on your phone and really can control. I mean, people need to step up and get to know their own phones and control notifications. I've got mine turned off for practically everybody. But yeah, there is a proposed law that just got introduced. So a bill was introduced by Senator Pallone from New Jersey on the 28th or 29th of January, so just about 6 weeks ago, that specifically is trying to undo what the Supreme Court did with Do-Good. Representative Pallone is saying, nope, there's going to be too much spam and auto dialing and auto calling because the Supreme Court clarified what the statute means. So let's rewrite the statute. And he wants to rewrite the statute to take out ATDS, the auto dialer, and replace it with robocall, and define robocall as any call or text made with equipment that makes a call or sends a text to stored telephone numbers. That will put us right back into the pre-Do-Good days, where every single kind of communication, wanted or not, your delivery is here, whatever, would be subject to arguments that, oh, hold on, that violates the TCPA, and now I can bring a class action up $500 a pop. Because while he wants to rewrite the statute to include all calls and texts with technology, one thing that is not being rewritten is the statutory damages.
Look, I mean, I think we can all understand the torment sometimes that getting too many spam calls can put us through. But what have been some of the unintended adverse consequences of the law, whether as it's broadly applied or even post Do-Good?
Well, I don't know that people are really aware of the strain that this puts on legitimate businesses who have to just get tortured about how can I most effectively communicate with my customers when I need to get something across that they need to know. And I have to sit and worry about getting a lawsuit under the TCPA. I had a client who sent one text message to everybody in their signed up text club. Everybody had opted in. Everybody had asked to get the text. And they sent a text message saying, hey, we're changing the phone number that these are coming from. So just to let you know, it's going to come from this new number. And because there was an error, a human error in sending that list, it went to some people that had previously opted out. And suddenly they got slapped with a $32 million class action lawsuit for one text message sent helpfully to people who had opted in. So it's also small companies. And I've had dentists and doctors calling me, and I've been helping them like on the cheap as much as I can, because they're getting sued and they're going to lose their house because they send appointment reminders. And they're getting arguments that the appointment reminders somehow violated the TCPA. The people who are not getting sued are the spam telemarketers that fill up your phone with spam. That's not legitimate businesses. You may have noticed, though, that those have been getting better as well, because the phone companies have been tasked with really policing spam marketing calls and texts. So yeah, there have been a lot of negative consequences. And anytime anything generates this much litigation, it's the consumers that eventually pay, because businesses have to build up giant litigation budgets and get the money coming in for those because of this statute.
Right. So you've got the cost of settling these cases, or perhaps even if they go to judgment, paying judgments. You've also got the cost of compliance as well. With respect to compliance, what do you think would be the most practical takeaways for anybody listening on this call who either has a client who engages in digital marketing of this type, or perhaps clients themselves? What should they be thinking about?
I mean, I just tell every company that if you're doing any outbound calls or text messages, or you don't think you are, go ask around, see if you're doing them. You need to have a communications policy, and it needs to separate out what are we doing for our transactional and informational communications, which have different levels of consent. What are we doing if we're going to do marketing? How are we doing it? And we're not going to do aggressive marketing. We're not going to slam people's phones. We're going to use this correctly. And we have to abide by all the state laws and federal laws if we do it. But let me tell you, really, one of the biggest dangers with this law is the vicarious liability. There were fights that ended in like 2013. The FCC said, yes, there's vicarious liability under all provisions that have a private right of action with the TCPA. So I've got companies that are setting laws and trying to do everything correctly. And then some independent contractor goes out and sends 1 million text messages. So you have to really know and put restrictions on how people can use your company name and brand in these kinds of messages. Otherwise, you're going to find yourself getting pulled in on vicarious liability allegations for something you didn't do.
Well, Becca, I'd be remiss if we didn't talk a little bit more about AI, because that's the hot topic that everyone's touching on these days. And I know you mentioned briefly that the new FCC rulemaking has brought AI underneath the umbrella of the TCPA. What does that look like in practice? What are the AI technologies that companies are actually using in this space? How do they work, and how will that interact with the TCPA following this ruling?
Everyone's trying to figure it out. Like, the AI chatbots have been doing really well at helping customers and helping companies filter only things that are more confusing over to their customer service rep, and the chatbot can handle a lot. And there's thoughts about doing that with texts, but what's holding that back is TCPA. And there was an argument floating around after Do-Good that texts were pre-recorded voice calls because they were written, but they'd have to be spoken at some. I mean, there were a lot of reasons they were arguing it. Those lost. Like, texts are fine right now. But it's interesting that Representative Pallone's proposed new bill would insert texts into the TCPA, would define text very broadly to include any communications with images or sounds or text, and would have artificially generated text, something tied to pre-recorded voice. So again, this bill, as somebody who is a TCPA defense lawyer and who works with numerous companies who are legitimate, good companies with happy customers who have ongoing needs to communicate with them, this new bill is frightening, because, it's the kinds of liability this lays on companies is really obscene.
Well, we'll have to see what happens with it. And if it does pass, you'll probably have a lot more business, Becca.
I spent so many years fighting ATDS and getting, as part of the defense bar, the joy of that win in Do-Good, and to have it undone would be a little sad.
Oh, well. Well, let's not end this episode on a sad note. Let's head into the last part of our episode, in which we try to get to know our guests a little bit better as people. First, what we'd like to ask is, tell us something interesting about yourself that is completely outside of your very busy law practice.
I guess outside of my law practice is what I did before I became a lawyer, because I was an English teacher. I was getting graduate degrees and taught at BYU and UCLA, and was heading to be an English professor, and then got distracted over into law, thinking I might be a law professor. Never thought I would be a lawyer. But one thing I've kept up on is reading. I'm a big reader, and I, in many ways, miss having a classroom environment to talk about books.
Did you have a favorite book or a favorite piece of literature to teach?
Oh, no, I can't. That's like asking me for my favorite child. I have thousands of them. But I do love, when I was teaching, pairing interesting books together that you wouldn't normally read together. And that was also a way to try to avoid plagiarism by giving my students really interesting connections.
Well, you're making interesting connections as a lawyer, too. Before we let you go, we're going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules of this game could not be more simple. Derek is going to draw a surprise random question from a virtual hat, and you get to answer it without any previous notice. Okay, take it away, Derek.
Becca, your surprise question today is, if you could choose free front row tickets for any performing arts show or festival in the world, what would you choose?
Oh, are we talking somebody who's alive, or can I go back to dead?
I think either one is fine. There's no rules for the curious.
Yeah, this is a highly hypothetical question.
I honestly can't believe I'm about to say this, but my niece had me watch that video of the Taylor Swift Eras Tour, and that tour looks amazing. And I would love to go sit front row and see that. Even though I hadn't thought of myself as a Taylor Swift fan, I've got to see that show.
Wow. Well, I kind of feel the same way, but I have heard it's an amazing show. And so all credit goes to Taylor Swift. Good answer. Thank you very much, Becca. And thank you, Derek. Thank you to our listeners. Tune in again next week for a new episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.